Good morning to all of you.
Good morning, sir.
Sir.
I formally welcome you all. Good morning. Once again, I formally welcome you in this engagement. We are going to deliberate international media law. Dear friends, international media law coursework tries to vet fundamental characteristics, basic traits, trends, of various legal institutional frameworks within the context of SAARC nations as well as at international context. In the framework of international media law, we are going to deliberate communication rights regime within which journalistic practices happen. My dear friends, you are well aware what exactly are the circumstances, practices, developments taking place in the arena of a media world or in the arena of media per se. We have been witnessing various developments in different parts of the world, including South Asia. Various questions are being raised regarding fundamental rights, communication rights, journalistic rights, independence of journalism, ethical journalism, investigative journalism, yellow journalism, sensational journalism, and other forms of journalism. And cumulatively, we are going to debate what is the future of journalism in South Asia or at international level or in the international context. Various aspects are there. Today, media is not confined exclusively to newspapers or magazines. But this is a world where we are studying different digital platforms. We are having the formal, what we call, journalism as well as informal journalism. We are having the journalistic journalism and propagandist journalism. As a journalist, it is our duty to think like a journalist, but sometimes we are not thinking like journalist, we are thinking like propagandist. As a political mind, as a scientific mind, as a rational mind, there are different approaches which are also adopted in the arena of journalism. But what is important is, my dear friends, what is going to be the future of journalism? Should we confine journalism exclusively on the basis of popular nationalism on the basis of globalization, on the basis of neo-imperialism, on the basis of neoliberalism, feminism, Marxism, or should we have a journalistic approach which is exclusively based on the premise which is known as far-right induced journalism? And that has become a global trend in the contemporary circumstances when we are, talking of journalism or journalistic mandate. So cumulatively speaking, we have to undertake the entire global picture of challenges, issues, concerns which are plaguing journalism in the contemporary circumstances. So that is the biggest what we call, and that should be the, our bone of contention in this particular engagement. Because we cannot, my dear friends, understand completely the idea of international media law in a course structure that has been designed exclusively for 2 credits. Though in future I intend to make it a 4-credit course, if it is permitted by the competent authority of the department. But it's a vast area. We are having lot of international organizations functioning in the area of freedom of journalism or free media. I have also alluded in my submissions in the comparative constitutional law classes, if you recall, that in today's circumstances, media has acquired 2 important visages. One is, in many geopolitical entities, media has become subservient to the governance architecture, which is currently being in majority of the situations presided over by ideological affiliations. Number 2, in some of, in very few situations, in very few geopolitical entities, my dear friends, media has been functioning or has emerged as an independent organ of the state. Then in such a scenario, my dear friends, what is the duty and what are the expectations of the general masses or the Republican character of the citizens in many geopolitical entities? What are their legitimate expectations from such a trend? That we have to understand and decipher what exactly are the contours and issues involved. Therefore, it is our fundamental responsibility to understand entire arena of media under international law, under constitutional law, or under comparative constitutional law of various nation states. Then only we would be in a better position to understand how media is studied, how media ethics, how media what we call understandings should be explored. There are many challenges before the media personnel, I mean the journalists. The biggest issue is, my dear friends, of safety of journalists. Because the journalists, my dear friends, particularly investigative journalists, they function at the cost of their life. In many countries, if you take into account how many killings have taken place in the last year, that is 2022, how many journalists have been killed in South Asia, in Middle East, Far East, Africa, even in European nation states, number of journalists have been killed because of what we call of hate crimes, because at the cost of their journalistic ethics and independence, because they were not what we call following the path of conformity, and they have become some kind of a thorn in the eyes of the establishments in various geopolitical entities. Many journalists are still languishing in jails in various nation states, and prominent among them happens to be the Egypt. So all these developments ultimately impel us to understand what should be the what we call our line of understanding, our line of research when we are talking of this kind of a course. And that is why, my dear friends, instant course which is I am going to offer, my dear friends, that is International Media Law. This course addresses multiple strands like regulation of publication to protect private interests, the regulation of the publication in defense of a range of public interests, and the facilitation and control of the pre-publication news gathering practices. These strands are also involved the dynamics of confidentiality, because nowadays we are witnessing a new kind of a challenge, and that is the confidentiality of the journalistic sources. A journalist is not at all under any kind of obligation to divulge the contours and contents of his what we call report and sources, where from he has gathered the requisite information. Reputation is another important challenge, along with what we call defamation, particularly the libel and the personal information abuse. And moreover, my dear friends, these strands encapsulate, my dear friends, a focus on prejudice to legal proceedings from media publicity. And there are organizations like SLAPP, SLAPP. So that also I would also be coming to that particular aspect, what exactly has been the role of this particular organization. But what is important is that there is a produces lot of prejudice in terms of what we call, and particularly involved in the legal proceedings from media publicity, publishing offensive content, publication of the sensitive material affecting national security and political impartiality concerns. These are the various strands which we should try to understand in this particular engagement. We have to understand different what we call legal frameworks as well, and that I would be coming at a subsequent stage. But other problems such as the consideration of law of contempt, blasphemy laws, and the associated public orders offenses, what we have been witnessing in the context of Pakistan, in the context of Afghanistan, and in the context of Bangladesh, in our part of the world. Therefore, we have to understand this, the official secrets and terrorism legislations and broadcasting bans on certain forms of speech have to be attended with a compendium of perspectives, including their emerging trend of shutting down of internet facilities or internet access. That has also created or added salt to injury. Therefore, International Media Law coursework, my dear friends, is bound to what we call address the issues involving surreptitious tactics and deceptive methods, like political subterfuge, hierarchical harassment and clandestine modus operandi for financial chicanery, and other kinds of what we call of deceptions which are generally resorted for reporting. Dear friends, the dimensions of protecting journalists sources, as I have already submitted, including technological circumventions in an age of artificial intelligence In an age of other important, considerations, what kind of, problems we have been, facing in terms of, protecting the, or providing any kind of, protection to journalistic, sources, that has to be taken into consideration as well. Another important, dimensions, my dear friends, or cumulatively speaking, I should say, that international media law provides a solid, what we call, foundation, or will provide a solid foundation with regard to understanding, or in the context of understanding of the fundamental constitutional principles, which are, or which should be the, inalienable companion of a journalist or the media, what we call, business. Constitutional principles, when I am talking of those very constitutional principles, my dear friends, which are relating to free speech and free press. We have to understand, my dear friends, the limits of the, government's authority to prevent or punish. How reporting has to be done with regard to what we call information, and the rights of the, reporters to access and confidentiality in news reporting. There is another important aspect which we should not forget, and that is the privacy. The privacy constitutionalism, we must understand. What exactly is the regulatory framework that has been provided by various geopolitical entities with regard to the, privacy concerns or the protection of the privacy rights? Lot of, judgments have been, delivered in different geopolitical entities on the right to privacy. In our own country, my dear friends, even the Honorable Supreme Court of India has also provided a remarkable decision in the arena of right to privacy. But we should not forget, my dear friends, whenever any kind of a privacy constitutionalism is deliberated or likely to be, talked of, then we cannot minus the idea of gender or gender justice. That must also be, taken care of. Another important idea when we are, talking of the regulatory framework of privacy, constitutionalism, then we should not forget the determinants of the law of privacy. We have to determine the province on the basis of these, determinants, that this is going to be the gamut and this is going to be the, canvas of right to privacy. So privacy constitutionalism constitute a very, very important dimension of our engagement in this particular, class, that is of, international media law. Another important, dimension to the ongoing deliberation is the emergence of the fake news industry. There are certain important legislations as well on this particular, context, which have been, promulgated by some of the states, particularly the state of California in United States of America has come out a legislation to curb the menace of fake news. There is another important dimension to the fake news, that is the deep fake news. That must also be, understood in this particular, engagement. Because what we have been witnessing, my dear friends, we have been witnessing when we try to understand media ethics and media law, when we try to deliberate the communication rights under international law. I would be coming what exactly is the international law, international legal framework which is available for regulating, understanding, controlling, monitoring, and managing the news industry. In addition to our national legislations and whatever the juris corpus that has been developed by various highest judicial establishments in our part of the world, including South Asia. Fake news, dear friends, and other legal what you call concerns, which are very much significant to the journalist fraternity. They have presented the biggest challenges. Artificial intelligence has further quelled the pitch of what we call of the fake news. I'm not here going to deliberate the application of the artificial intelligence and its legitimacy in creating. But even the human beings have also become the another source of fake news, because the user generated content on internet has become another important challenge in the name of social media, in the name of freedom of speech and expression. You are well acquainted what happened yesterday, my dear friends, in Sweden, in the name of the freedom of speech and expression. A very tiny country called Sweden which is having a population of only of the 1 crore plus, has allowed to burn the copy of the Holy Quran in the name of the freedom of speech and expression. I am not concerned about the credentials of that very individual or the political affiliations of that very individual. My only concern is the constitutional principle, the idea of constitutionalism, or ethical, journalism. We do not have any kind of a reporting or any kind of a opposition of these kinds of actions on the part of an individual. That is why, my dear friends, racism or religion-induced racism has become a political communication in many parts of the world. Hate-driven communication has become the part of what we call of political communication in many geopolitical entities. That has presented the biggest challenge, my dear friends, when we are talking of freedom of media or the freedom of speech and expression. That includes media freedom. There are countries, particularly there are educational institutions like a University of Wisconsin, University of Johns Hopkins, where you will find, my dear friends, a novel research have been produced on these what we call these challenges of the fake news and the sham freedom of speech and expression. Our collective and basic and the most fundamental teachings tell us that we should be very respectful to the religious scriptures of each and every religion. How a woman journalist was killed by the armed forces of Israel in the recent past, most recent past. How to address these kinds of challenges, my dear friends, that is $1 million what we call question. If you take into account and try to understand as a case study, South Asian judiciaries have also delivered the landmark decisions And we should try to understand how the freedom of speech and expression as well as the media freedom should be ensured. What should be the threshold of the liability of the criticism and the defamation of the governmental officials and other public figures? And this reminds me, my dear friends, of a very famous case that was delivered in United States of America, that is in New York Times versus Sullivan. So therefore, I try to make a presentation today of the entire course overview and the course structure of this particular paper, and that is international media law. And my advice would be, my dear friends, that some of you must try to understand, consider that there are a lot of prospects as a journalist in this particular area, if you are seriously engaging yourself in this particular field, that is international media law. It's a highly captivating field of study, my dear friends. You, at this stage, you are in a better position to understand, because I am addressing lawyers, not students. So all of you are lawyers, though formally you have been drafted as students of international media law. My dear friends, in the very first engagement that we have started in the week one, we are going to understand, and I'm going to introduce you to the various contours of international media law. We are going to understand, my dear friends, the concept of media law, fundamental principles of the media rationale, international norms of the media law. And there are certain specific questions which we are supposed to address by conceptualizing media freedom, technological, social, political context of media freedom, and other important aspects. What is the crisis in media? Crisis of credibility, crisis of what we call of safety, ethics, and other important what we call technological influences. We have to what we call address all these things. In the very first engagement, my dear friends, I am supposed to deliberate how should we try to think. What are the contours when we start thinking like a lawyer, thinking like a journalist, and thinking like a scientist, or thinking like a social activist? We have to understand the different contours. We have to what we call appreciate what has been the role of media in law making, law depiction, and how the issues are generally raised, and what has been the contours of the media trial in day-to-day understandings. At the same time, my dear friends, it is equally important, and it is the fundamental responsibility of media houses as well as the journalists, and particularly those who are talking as academicians or the university professors, instructions, or the student community, or the advocates who are practicing in the area of freedom of speech and expression. They must try to understand and establish the credibility, particularly in evaluating race contours, culture, gender identity, citizenship, and other important aspects, including the forced migrations, rights of refugees, and other important immigration related issues. How these issues, including what we call climate change and other important propagandas, which are generally pursued by the media houses, what kind of understanding should be there of all these issues and developments which are taking place in the arena of what we call of international media law. There are certain important what we call frameworks which must also be taken into consideration, my dear friends. This is equally important to understand the various aspects of the international media law. My dear friends, I would like to supply or share with all of you, when we are talking of international legal frameworks which are available in understanding the various aspects of international media law. This reminds me of 1936 International Convention on the Use of Broadcasting, in the cause of peace. This is one international, convention that was adopted under the auspices of the the League of Nations. Under the mandate of the Charter of the League of Nations, this particular, convention was adopted, and particularly Article 3, subclause 2 of this convention becomes very, very important, and that constitutes our what we call, cup of tea, and we have to what we call, evaluate it. Then, my dear friends, another important article is also there, that is Article 19 of the Universal Declaration of Human Rights of 1948, that must also be, understood. In evaluating, understanding, appreciating on critical footing international media law, media freedom, and freedom of speech and expression. Then there is another important, framework, particularly I'm talking of the 1977 additional protocol to the 4 Geneva Conventions of 1949, which you are going to study as a subject matter under international humanitarian law. So this becomes another important what we call, bone of contention when we are, talking of communication rights as well as the media freedom. Then there is another important regional mechanism which is available in Europe, and that is the European Charter of Human Rights, Article 10. Article 10 of the European Charter of 1951 becomes very, very important, and we should not what we call, forget that there is another important what we call, convention on the international right of, connection that was adopted by the international community in 1953. There is another important what we call, deliberation, which is axiomatic, which emerges out of what we call of, 1966 UN Covenant on Civil and Political Rights. Again, my dear friends, it is Article 19. Then 1978 UNESCO Mass Media Declaration is also there, that is in public domain, and we have to understand. And UNESCO has been publishing various reports annually on different what we call, patents, trades, inputs, freedom index, thresholds, as well as what we call, University of Columbia has also what we call having a separate, initiative. Then there is another important what we call, organization which is known as the Chatham House. There is another important what we call, organization which is known as the Freedom House. So all these what we call, there are, other important, institutions, research institutions and think tanks like what we call, Pew Research, Center, and other important what we call, think tanks who are functioning in the area of media freedom, and their reports going to be a very, very important, subject matter for our, engagement, our research engagement, as well as our deliberations. We have to understand cumulatively all these what we call, contributions. Another important deliberation, my dear friends, happens to be of 1991 Windhoek Declaration. Windhoek Declaration has exclusively been what we call, designed for promoting independent and pluralistic media, my dear friends. And therefore, when we are, talking of the Windhoek Declaration, my dear friends, sometimes I find the normativity aspect in this particular, declaration, and that normativity aspect basically having some kind of a, constitutional, principles. And therefore, this declaration must be understood on our, fingertips. Another important engagement, my dear friends, would be 2001 draft articles on responsibility of states for internationally wrongful acts. And there are two important specific articles in this particular, draft declaration. That is Article 35 and Article 37. These two important articles constitute a very, very important, engagement, which we have to, understand and undertake. Another important aspect which I would like to bring to your kind notice, my dear friends, there are certain important what we call SDGs. Sustainable Development Goals. When we are, talking of international freedom of media or global media freedom, then we should not forget, my dear friends, Target 1610. That is the very, very important what we call, goalpost that has been contemplated in 2015 as one of the, objective under Sustainable Development Goals. Under this particular target, my dear friends, that is 1610 or 16.10. Under this particular goal, we try to seek protection and justice for the freedom of expression and information. There are certain important resolutions of the United Nations General Assembly. United Nations General Assembly Resolution of 1990 on information in the service of humanity. Again, the UN General Assembly Resolution of 2014. Then further it has been improved upon, and some additions have taken place in the year 2016 as well as what we call 2017, and that is why it becomes necessary to understand all these aspects. And UN Human Rights Council resolutions are not far behind, my dear friends. Even the UN Human Rights Councils in 2012, I think, have also adopted certain important specific what we call resolutions. Then United Nations, very important United Nations Security Council resolutions, which is even the number is known as the Trata 2. I mean, the 4 times you have to write 2, that is Trata 2. So that is the number of this particular United Nations Security Council resolution on the protection of journalists. Separately, it has been adopted to protect, I mean, the journalists, media professionals, media personnel, and associated personnel during the armed conflicts. And it was the resolution which was adopted in the year 2015 by the United Nations Security Council. Then again, UNESCO General Conference resolution is also there, that was adopted in 1989. So that resolution also constitutes, my dear friends, as a main focus, particularly on promoting the free flow of ideas by word and image at international as well as at national level. So these are some of the important what we call frameworks with which we have to what we call advance our understanding of entire media law or the media. My dear friends, in addition to all these developments, we are supposed to understand various writings which are currently being contributed by the student community, journalists on social media and other digital or internet platforms. That is going to be the I mean the subject matter of our engagement. So far, the primary sources of international or global law on media freedom are concerned, we should not forget whatever the regional human rights courts, particularly the judicial organs in Europe, the European Court of Human Rights and European Court of Justice, Inter-American Commission on Human Rights, Inter-American System of or Inter-American Court of Human Rights, African Court of Human Rights, and there are certain important regional what we call bodies in Asia, in Africa, and their reports are going to be another important feature of our deliberation in this particular engagement. This brings me to another important week, and that is the week 2, my dear friends. As a part of my today's orientation, as a part of my today's presentation of an overview of the subject, week 2 becomes very, very important, because in this particular week we are going to deliberate media development, media pluralism, media technology, and media law. So media pluralism is of vital importance, my dear friends, because we have to take into account the entire development history of what we call of the media, particularly in the context of regionalism, in the context of internationalism, or as a what we call novel presentation, which I called media instrumentalism or media iconoclasms. So this is how we have to understand this entire philosophy of media pluralism. In this particular engagement, my dear friends, we have to understand how to contest or contesting the media in the globalized world, because we have been witnessing the emergence of the media technology at international level, at regional level, particularly at European level, and national mechanisms which have been designed for media law. What exactly are the types of media when we are talking of media pluralism? There is media or internet media. Then we have to understand the idea of the universality and the idea of what we call ROAM, ROAM. Then we have to understand what exactly are the contours of the broadcast media, digital social media, OTTs. OTTs platforms have become the most what we call preferred destination for seeking news, for entertainment, for infotainment, I should say. And another important aspect of the OTTs happens to be the web series, what we call media. Private and public ownership issues are also there. What exactly are the ownership patterns which we have been witnessing in this particular context, and what is the difference between the usual and non-visual what we call media, or visual and non-visual what we call communications. Law and reality television, that is another important aspect which is emerging, and other what we call aspects are also there, particularly like WhatsApp, Google, Netflix, Amazon Prime, or Disney plus Hotstar, all these kinds, including Twitter. And what exactly is happening regarding Twitter, what kind of inside, what are the inside stories, particularly with relating to the management independence, ethics, and what has been the what we call the role of the new owner and his commitment. I'm talking of what we call the Elon Musk understanding of the media freedom, public and private what we call understandings, and what kind of a public and private partnership is there. And we have to understand, my dear friends, at the same time, media impact on people's minds, impact of films, censorship of films, and standards of what we call of censorship. Because it is a very, very vital question, my dear friends, when we are talking of the people of media, because there are institutions, there are institutional frameworks, there are institutional mechanisms, there are international as well as the national certification boards, where after what we call the proper vetting, screening, everything is documentary, a film, a web series, a feature film, or any kind of a clip is passed. But even then, the journal masses, with their own understanding of the different what we call approach or approaching a particular issue, they are also started sitting in judgment. And the biggest what we call controversy, contemporary controversy, is before us, and that is relating to a Bollywood movie who is currently being boycotted. So you can understand, once an institution, an agency, a governmental agency has passed and certified the contents of a film, then how subsequently in the public domain individuals or a group of individuals can take law in their own hands, and they are going to decide the fate of a particular a movie. It means it is basically underestimation, it is undermining, it amounts to undermining of the constitutional bodies, statutory bodies, and the legal bodies which have been contemplated and passed by the parliament of a particular geopolitical entity. And this is what we have been witnessing. So it becomes very, very important, my dear friends, to understand media pluralism. Then we third takes into account the normative framework of the media what we call freedom, media culture beyond normative de-westernization and reimagining the global south in media, and particularly the idea of what we call the free speech, access to what we call information under international law, and legal institutional limitations in the SARC jurisdictions. What kind of limitations have been contemplated? What kind of I mean, our constitutions, how our constitutions have been dealing with the idea of the media freedom as well as freedom of speech and expressions. So that is why it becomes very, very important, my dear friends, that as a student of the comparative constitutional law of SARC nations, as a student of constitutional law per se, or as a student of international what we call students community, in understanding the internationalism of the constitutionalization as well as transformative constitutionalism, we have to understand the normativity and the normative framework of for media freedom beyond any kind of de-westernization. Because when I'm talking of, I have been very careful in taking into consideration this particular aspect of de-westernization. Basically, I'm talking, though it's a very euphemistic kind of term, it's a very utopian kind of an expression, but basically I intend to deliberate in this particular expression, that is de-westernization. Basically, I'm advocating the idea of a decolonization, because what we have been witnessing, that it is not the civilization, it is not the civility. Because if civility somebody is talking of, then we have to understand, my dear friends, the contours of civility. And the foremost and one of the most important argument that comes to my mind when we are talking of journalistic civility or the civility of a citizenship, the very first criteria, and I hope you are going to agree with me, and the criteria is that we have to determine civility of institutions, civility of nation states, civility of the individual citizenship, civility of the governmental agencies exclusively on the basis of human dignity. So the Western nation states cannot claim themselves they are hailing from the community of the civilized nation states. No. There is a requirement that we should de-westernize ourselves, decolonize ourselves. There is a requirement of the decolonization of journalistic or journalism per se. There is a requirement of the decolonization of education. There is a requirement, unprecedented requirement in the contemporary circumstances when the global South economies are emerging and far ahead if measured against their counterparts in the global North. Then we require the decolonization of everything, because what I have been witnessing, my dear friends, for the last, particularly for the last 20 years, or in the first quarter of the 21st century, and that is started, my dear friends, in the later half of the 20th century. So for the last, almost 75 years, I can say, we have been witnessing the recolonization, re-westernization, and how this has been presented as globalization. Globalization is nothing but it is re-westernization. So whether it is journalism, whether it is technology, whether it is education, whether it is our course structure, whether it is educational mechanisms, educational structures, or institutional, frameworks, particularly the universities. Why it has become a fashion that if anything has to be good, it has to be found in Western educational institutions. Instead of emulating them, we should compete with them. Whether it is copyrights or the patents or other important arenas, you will find in the area of what you call of scientific inventions, technological advancements. People from the global now, I mean global south, have migrated. Those who have migrated from our part of the world, they have contributed, and many of the patents have been patented in their names. So there is a requirement, particularly in the context of media trial or media freedom. We have to de-westernize it as a normative argument. We must not what you call fiddle with. We should not meddle with our normative argument or the normativity of our system. So there is a requirement, my dear friends, of the de-westernization, and this de-westernization must take place from the South Asian what you call nation states, and that is why when we are talking of how to locate, how to reimagine the place of global South or the South Asia in media, then we have to examine, my dear friends, the idea of free speech, access to information, how international law treats all these kinds of goalposts, and at the same time we have to understand international law and legal institution limitations in the context of the SAARC jurisdictions, and understanding media freedom and limitations on media freedom in our part of the world, and how it is going to be materialized. We have to study law and popular culture. We should try to understand the methods and the reflexivity of the free speech protection, as well as what kind of a protection has been made available under international law. So we have to take into account, when I'm saying international law, my dear friends, you must qualify international law with an adjective. I'm talking of not globalized international law or the globalized world, rather I'm talking of the decolonized world. We have to decolonize all these aspects, then only we can understand. And at the same time, my dear friends, we must undertake the idea of what we call of different aspects, particularly defamation law, hate speech, racial speech, blasphemy, and other important what we call targets which have been envisioned, like a global target which is known as goal number 16 as a part of SDGs or the Sustainable Development Goals, where we are supposed to undertake some kind of information and how to seek that very information, because seeking of information is equally important. That brings me to another important what we call week, and it is the week 4, where we are going to study, my dear friends, emergence of the media as the new state organ and how it has been dealt with under the law. So it is a extension of my deliberations which I have already submitted in the class of comparative constitutional law of SAARC nations. So we have to take into account the idea of interdependence of the legal institutions and journalism, and the liberal media doctrine. We have to locate particularly what is the positions of the most of what we call liberal democracies. But yesterday was the best example of a liberal democracy. That was the burning of the Holy Quran. So Sweden, as a civilized nation state, has already proved its civility as a nation state. What has been the threshold of the erosion of the human dignity, so that they have already established. And these European nation states have been talking of civilizing African people and Asian people. So it is for us to decide to whether it is permissible, whether the conditions, restrictions, limitations, riders, conformities, whatever have been contemplated in our constitutional doctrines or constitutional orders, then this shows our what we call, maturity of our ancestral wisdom, our antique what we call, wisdom. When the constitution, the oldest constitution in South Asia is the Indian constitution. When in 1950, when it was inaugurated, and prior to that, even during the Constituent Assembly debates, our forefathers have rightly what we call envisioned that freedom of speech and expression cannot be an unruly horse. It requires some kind of restrictions, and that is why they have contemplated as many as 8 restrictions which have been attached to Article 19 of the Constitution of India, which takes into account the freedom of speech and expression. So that was the what we call idea. They contemplated even prior to that also, my dear friends. Civility in each and every geopolitical entity came out with this kind of social norms, how to behave. There are certain important, there is a mannerism of behavior. There is a what we call some compendium of etiquettes, and it includes how to behave, how to conduct at public places or in the 4 walls of a household. So in the name of the freedom of speech and expression, in our own households, my dear friends, can we abuse our elders? Can we admonish, upbraid our youngers? There are certain important red lines. These red lines have been designed after a careful consideration by our ancestors. And that is why these red lines are also reflected in our constitutional documents. We cannot have some kind of a duality in our character. Duality in our character, my dear friends, is basically, if it is there, it basically disintegrates our personality. It does not take into account, same is the, we can apply the same line of argument to the, sanctity of a nation state. It is equally applicable to the integrity, integration, as well as what we call, territorial integrity, civility, and civilization of a geopolitical entity who claims itself to be the most civilized nation or among one of the, civilized nation states. That forms the, basis of our, understanding. It has become very difficult, my dear friends, that even we cannot approbate or we cannot, come out if there happens to be any kind of an altercation or any kind of a, contest between the 2 persons at a public place. We cannot side with any of them. We cannot side with them. So this is the most important, I should say, a normative crisis. I see it. That is why in international media law, or when we are talking of the emergence of media as a separate independent individual institution or organ, then protection of the confidential sources constitute a very, very important aspect, including the protection of the whistleblowers, privacy protections, surveillance, encryption, and breach of confidentiality. Or in other words, you can put it like this, my dear friend, make believe words of law and the mass media. We have to protect under all circumstances the autonomy, sanctity, as well as the impartiality of law. When we are talking of autonomy, then we are basically talking of that there should not be any kind of internet curbs, internet shutdowns, internet content removal. This should not be what we call done. national security and countering violent extremism requires some kind of a foolproof mechanism. But this is not there, despite the fact metaverse has also developed. Even Twitter has also developed all kinds of what you call of if hate speech induced contents are there, if these kinds of contents are populated, uploaded on these kinds of internet platforms, then it is the sole responsibility of the corporate houses, the managers, the regulators, as per law. Because these institutions, these platforms do not suffer from the inadequacy of law. There are plenty of laws. These plenty of laws are available on each and every aspect too. If something provocative item is uploaded, racially provocative or religiously provocative items are placed in the public domain, then there are mechanisms, there are legal what we call safeguards, and these legal safeguards are required to be invoked. But generally what we have been witnessing, that there are certain political constituencies, if any material which is available on internet and that is that conforms to the political ends of a particular political outfit, then they are not bothered at all. And that is why, my dear friends, we have been witnessing an element of othering. An element of othering is taking place within the geopolitical entity at international level. It is the neo-colonialism. It is the coloniality in the mass media structures that is basically dictating the what we call terms. I have already shared an example with all of you, and that is a very, very horrendous kind of example. Then here lies a vast canvas of good governance of what we call of the freedom of speech and expression. Because when we are talking of media pluralism, we are also talking of the gender pluralism. When we are talking of media pluralism, we are also talking of the gender justice. In terms of representation, we are talking of gender equality. In terms of what we call of employees wages and other important what we call perks and benefits, we are talking of freedom of journalists. So this is something we are supposed to deliberate in this week. Then another important week is the week 5. In the week 5, my dear friends, we are going to discuss privacy, right to privacy, or the primacy of privacy, you may call it. Because in today's world, privacy is the biggest casualty. There are individual rights, there are collective rights. There are violations of these rights. There are discriminatory practices, there are targeted discriminations which are taking place. Fundamental human freedoms have been trampled upon under the bandicoots of or power bandicoots of the power structures. We have been witnessing on daily basis the circumventions of these rights, transgressions of the fundamental human freedoms. We have also been, as a form of, violation of fundamental human rights relating to privacy, we have been witnessing obscenity, pornography, child pornography, and other forms of what we call of, violations are also taking place. So therefore, when we are, talking of privacy, it has become a trend that we have to, if at all we are interested to understand the contours of privacy, then it has become necessary to understand the entire gamut of law of privacy as well as what constitutes privacy. When I am talking of the entire gamut of privacy, my dear friends, I am basically taking into consideration that in contemporary circumstances or in the contemporary social milieu, every human activity has become the part of law of privacy or right to privacy. This brings me to a very, very important evolution. And this is how I try to reimagine the idea of privacy. Is there any feasibility to explore? I will let you know the arguments and the reasons why I am saying this. But let me put forward for your consideration. Is there any kind of a feasibility to have some kind of a public privacy within inverted commas and private privacy? Because there is a argument in public domain. The such and such action of a movie, of an individual, of an agency, of a corporation, of a geopolitical entity, of a international organization violates our religious feelings. It is generally alleged that some people are there, or a group of people is there, or a group of individual is there in the street, and they are demanding that this particular depiction is a violation of our religious right or the our religious sentiments. So to what extent the religious sentiments constitute or becomes the part of the public privacy? Then there is another important argument to it, and that is the idea of private privacy. When I am using this word private privacy, my dear friends, I am of the view that what constitutes what should be the content, because what we have been witnessing over the years under right to privacy, if from my family members there are some public figures and they are discharging some public obligations, if anything detrimental, obnoxious and hazardous is identified in their domain, shouldn't we exclusively confine to that very individual whenever any kind of a legal proceedings is started? Now it has become a trend. A trend, if somebody has committed from a particular, suppose an individual from a family, and there are many individuals in that very family, and they are what you call living under the common roof. If that is some one individual has committed any kind of a crime, though it has not been, judicially approbated, he has not been convicted of his or, for his, crimes. But there are, allegations of some commissions and omissions punishable under the law. Then on the basis of this kind of, commission or omission, media trial starts. And even other what you call, individuals from the same family, they are also what you call, targeted. So this is how I try to, visit this particular, argument as a, strand of, private privacy. So we have to what you call, determine the entire province of, privacy. So that has to be taken into consideration when we are, talking of what we call of, just to elicit some kind of an information from the person who has been arrested, who has been what we call, taken to task by the law enforcement agencies. Other members of his or her, family should not be targeted in the name of what we call of, extracting some kind of, data, because the data protection laws are also there. There should not be what we call violations of their human rights. There should not be any kind of a violations of what we call of reputation. There should not be any kind of a seeking of the privacy information. There should not be any kind of a DNA profiling. There should not be any kind of an abuse of the personal information. Only information should exclusively be confined to that very individual, or as generally, I mean, the information which is collected by the law enforcement agencies or the national governments and each and every geopolitical entity as a part of the social security drive. Like in India, it is Aadhaar card, social security cards, or other kinds of cards in other geopolitical entities. So that constitutes a limitation, because the media freedom cannot be an unruly force. Rather, primacy must always be attributed to the privacy. But there may be certain important exceptions to this particular what we call rule. Now, there is another important week 6. Week 6, my dear friends, takes into account media ethics. Media ethics constitute, as I have already submitted at the very threshold of my today's submissions, media ethics constitute a very, very important what we call, notion of understanding or concept of understanding when we are taking into consideration the idea of media freedom. Because there are certain important what we call works, copyrighted works. And these copyrighted works demand that their sanctity must be what we call protected. There should not be any kind of a plagiarism or pirated what we call there should not be any kind of a piracy. If there has to be some kind of a what we call media trial, then the in-camera proceedings have always been recommended. Media ethics demands journalists must conform, and they should what we call hold the high standards of media reporting, particularly in situations of the sensitive court reporting and court cases. Ethical reporting must be there. And ethical reporting, my dear friends, also ensures the preservation, promotion, and protection of certain fundamental human freedoms and human rights. It is expected from the journalist they should behave like an umpire. There should not be any kind of a ethical dilemma or any kind of a ethical moral ambivalence on the part of what we call of journalists. And particularly the issues and concerns in mass communications must be addressed exclusively on the basis of the foundations of ethics. Because ethic is something, my dear friend, or ethics are something that is available to each and every what you call, aspect of our engagement. We have to undertake entire broadly of what you call of, ethics. No field of human activity, no area of human existence is free from any kind of, ethical content. In each and every aspect of the human engagement, ethics are, or it should be at the forefront to interact or to engage with anybody. If we are visiting to a doctor, then there is a role of what we call the medical ethics. If we are visiting a lawyer, then the legal ethics as well as the professional ethics are, there. If I'm engaging you, then my engagement as a, academician with all my students also demands an ethical content. So educational, what you call, or institutional ethics is a requirement. Entire compendium of the ethical, what we call, content must be in operation whenever any kind of, engagement is taking place. Same is the case with what we call, biological, what we call, experiments. We are also having biological, ethics, scientific ethics, neurological, ethics. So we are not free from, and this is, my dear friends, it is beyond the idea of what we call of, morality. Ethics are the biggest and the most important, red lines in our engagements, which determine our, level of interactions and thresholds of our, interactions. And that is why we must, protect journalist, sources in an age of, digital world or the digital age. We have to take into account a novel, project to build a digital safety for journalism. Extrajudicial regulation of media content must not be what we call, there, but press complaints and editors code of, practices must also be, promoted. So that is the what we call, visage of this particular, week. Another important week, that is the week 7, my dear friends. It is media and communication rights under the constitutional law frameworks of the, SAARC nations. We have to undertake, my dear friends, in this particular, engagement, certain important what we call, normative considerations are there. We have to try to establish what are the, nexus, interconnections, or connections between media and constitutions, rights and political ideology, democracy, pluralism, and what we call, media. We have to undertake how to determine the geopolitical province of media freedom and free speech, and right to free speech and expression. What is the what we call, content? What should be the content, and what are the, limitations, and to what extent it must be allowed to violate or to what we call uphold right to privacy, right to protection against the hate and racist what we call, speech that is equally comes into play when we are, talking of this particular what we call, week that is exclusively devoted to the SAARC nation states. So our constitutions becomes very, very important, my dear friends. We have to undertake not only the, constitutions of the, South Asia, but we have to take into account other important what we call, legislations, other important, codes. Suppose the Code of the Criminal Procedure 1800 what we call, 98. That should be, taken into considerations when we are, talking of, if I begin from the, Bangladesh, we have to undertake this. Again, in the context of, Bangladesh, my dear friends, there is another important, legislation, Official Secret Act 19, what we call, 23, Contempt of Court Act of 1926, then the Printing, Press and Publications Act of 1973, that must also be, studied. Then the Special Powers Act of 1974. Then the Newspaper Employees Conditions of Services Act of 1974, passed by the Bangladesh Parliament. Then the Copyright Act 2000, Information and Communication, what you call Technology Act 2006, and particularly, my dear friends, and I would like to educate myself from the students from Bangladesh, particularly the section 57 of this piece of legislation that constitute a very, very important what you call deliberation. Then another highly notorious in the recent what you call recently in recent days, in recent months, another very notorious piece of legislation passed by the and that violates the fundamental human freedoms. This is the journal allegation, and it is the Digital Security Act. In case of India, my dear friends, after Bangladesh, if you take into account, in addition to the constitutional provisions, then the Press and the Registration of Books Act we are also having in India, Vernacular Press Act of 1878, then the Telegraph Act of 1885, then we are also having the Newspaper Incitement to Offences Act of 1905, then the Copyright Act of the 1911, then a cinematographic what we call piece of legislation of 1918, then the Indian Press Act of 2010. Many of them have already been what we call changed and fine-tuned with the emergence of globalization in the area of intellectual property rights, like the if you take into account the patent what we call convention, as well as what we call the copyright convention and other important conventions at international level. So these some of the provisions of these piece of legislations have been conformed to those very piece of legislations. Then we are having Nepal, another Pakistan, Sri Lanka, Maldives, lot of piece of legislations, national legislations are there. But what is important is, my dear friend, is the constitutions of the SAARC nations, particularly relating to the freedom of media. Then in case of if I am allowed to take into account, because we do not have any constitution in Afghanistan, so as a part of SAARC nation states, I am still what we call having the 2004 constitution, though I have to consult some other important specific what we call developments in Afghanistan. Another important development that is equally important, that is a development relating to the 1964 constitution, some of the portions of this constitution for the sake of governance. Taliban regime has borrowed some of the provisions of this constitution. But if you take into account, my dear friends, the 2004 constitution, then the preamble remains irrebuttable in the context of what we call of the human freedoms, particularly the freedom of speech and expression. And 2004 constitution's article 34 as well as article 50. In case of constitution of Bangladesh, it is the preamble and article 39 of the Bangladesh constitution that must be studied. Then we are also having the constitution of Bhutan of 2008, preamble plus article 7 subclause 5, that is exclusively devoted to the freedom of speech and expression. Then Maldivian constitutions, article 24, 27 and 28, that is another important. Then Nepalese constitution, article 17 and article 28. Article 28 is exclusively devoted to the preservation and promotion of the right to privacy. And in case of Pakistan, it is article 19 and article 19A and article 28 of the constitution. And in case of what we call of my dear friends, India, it is article 19. And in case of Sri Lanka, it is article 10, 14 and 14 subclause 1A. So these are some of the important provisions. So we have to undertake these aspects. That takes me to another important week, that is the week 8, where we are going to understand the free exchange of information and emergence of the alternative news platforms and beyond. So this is another important, we have to undertake the idea of what we call of the fake news, the deep fake news, anarchy, national security, as well as other important interferences in the media, what we call, policies, how the foreign policy contours are going to shape, how international relations are affecting, and many other important, what we call, aspects, particularly the radicalizations and the radical speeches, racial speeches, political, what we call, parties and their roles in the media freedom, civil society, and the artificial intelligence, what we call, technologies, and other important, what we call, platforms like Wise and other, softwares, freedom law and alternative news. So here, what exactly is going to be the idea of, alternative news and expressions? And there are certain important, documentaries as well, which I intend to, what we call, share with you, and you can also see in those, documentaries. And the week 9 takes into account the media independence, media regulation, and media, what we call, monitoring. All these aspects have been undertaken under this particular, understanding, and that has been placed under week 9. Then I'm also having another important, week 10. The week 10 constitute a very, very important, what we call, because here in this week, that is the week 10, we are going to understand the framework for media freedom. Is it okay to say that the current, what we call, framework for the media freedom is, sufficient? Or is there any kind of a, possibility to contemplate a new platforms and new players and business and economic, what we call, models, media and information, literacy, reporting on, marginalized, what we call, populations, users generated, what we call, content, and democratization of the news, what we call, production, representation of gender in media, decision making, rights of, journalists and their jobs, a good environment for fostering journalists, adequate qualifications for working journalists, pluralism in media ownership, competition collapsing, and how the, boundaries of, what we call, of the media and technology are going to shrink. So everything we have to, what we call, undertake and try to, what we call, explore. Is there any kind of a, possibility to have any kind of a, common future for media freedom? And the week 11, my dear friends, takes into account the emerging spheres and the spaces in international media law. Suppose the new media, citizen journalism, bloggers, vloggers, right to be politically independent journalist, rise of the, social media, media imperialism, internet, and delivery of the legal services and online legal self-help forums, lawyers and lifestyles, and cyber, what we call, advice experts. Every day, legal, what we call, experience. What has been the, experience of the media confrontations and the media interactions on individual basis, on community level, or on tribal level, or on what we call, of, at a religious, what we call, level. What has been our, individual experiences or our collective, experiences. And this is something we are going to deliberate in the week 11. And the week, what we call, 12, we are going to have presentations and other important, engagements and critiquing of international media law. So with these words, my dear friends, I submit, and I formally once again welcome you all. And if you have, questions, you can, what we call, pose those very questions to me. Any questions? So those who are present, their attendance has already been conducted by the Google Meet. So I would be having the transcript of those. So don't worry about your attendance. Attendance has been, marked. And after 5th of February, there is every possibility that we are going to have face-to-face interactions in the new campus. So if you have questions, and I hope it's an optional paper, all of you who are present or attended today's, deliberations, they would be the part of international media law. So thank you very much for the day. If you have questions, queries, you can put forward, and I'm going to deliver a full-fledged lecture next week, and we are going to complete the very first week. Yes. Mr. Abhijit.
Yes, sir. Good morning, sir.
Good morning. Yeah.
Yes, sir.
Yeah, Miss, there is a, in the chat box, Miss Khadka has written, so what about a term paper? Yes, you have to write a term paper. Don't worry. Whether it is a 2 credit course or the 4 credit course, the requirements are, same. So you have to write a term paper. I have already, not you, but yes, I will make an email. So please be careful about the deadlines. We are already late in starting our classes. Instead of 11th of January, we are starting on 23rd of January. So we have to be very careful. So this is my sincere advice to all of you, and with the request, please follow the deadlines very regimentally. Yeah, Mr. Nouri from Afghanistan.
Hello, sir.
Hello. Do you want to say anything?
No, sir. Thank you, sir.
Thank you. Yeah, Mr. Islam, Iftisham Islam sir, everything is
Yes,
fine, I
sir.
hope.
Assalamu alaikum, sir.
Walaikum Assalam.
Yes, sir. I'll be there in the campus in 7th February, sir. Inshallah.
Yeah, sure. So thank you very much, my dear friends, for attending this class. And meanwhile, I would, further, supply the requisite material for your further, deliberations. So thank you very much. Enjoy the day. I wish you all the best. See you next time.
Thank you, sir.
Thank you, sir.
Thank you.
Thanks, sir.
Thank you, brother. Thank you.